disputes. And I asked this doctor how many disputes this system had. He said, well, we don't have any disputes. I said, well, possibly that's because there's no way to complain about problems. As a result of interactions we've had recently, they are actually going to put a button on these things that will allow people to complain. Mr. de Bronkhart, who has all kinds of problems, one problem he didn't need was to have on his record a statement when an x-ray was taken that it was an x-ray of a 53-year-old female. Mr. de Bronkhart was more persistent than I am, and he decided he needed to fix that. And he couldn't fix it, but the hospital system did put at the bottom, this person is not a female. The problem with all of this is how information is used. And we have to be very careful about how information is used. Because once it's in electronic form, we should be paying a lot more attention to anticipating consequences of its use. But even if we do pay attention to it, this is, entrepreneurs want to use information in an innovative fashion. And innovation means that we haven't thought about it. The Web 2.0 phenomenon in which entities, the value of entities is based on the value contributed by users, well, that's innovative, and that makes a lot of sense, but it generates conflicts. eBay, I was interested to hear Collins say that these other entities, Web 2.0 entities, don't have good business models. eBay has the world's best business model, or at least originally it did. Its original business model was, we'll provide a space for buyers and sellers to come together, and we'll assume no responsibility if anything goes wrong. We just take our few cents or few shekels whenever a transaction occurs. Well, that's a wonderful business model. Second Life doesn't resolve disputes because Second Life doesn't want to be responsible or liable, because if it undertook to settle disputes, then it has the same business model. We'll provide this virtual world, and we're not responsible for anything that happens. Well, eventually that disclaimer of responsibility doesn't work perfectly, but it works for a while. In any event, I think we're in an age in which we're using information creatively. Our current administration is focused on using technology in novel ways. That inevitably is going to generate more attention given to disputes, and I think inevitably it will give more attention to the field of ODR. So, thank you very much.
I realize I've been a very relaxed chair up until now, so now I need to actually do something. I feel we have been very fortunate to have these rich and insightful presentations open our deliberations today. And indeed, the mix of systems, dispute types, topics raised in these 4 presentations provides an excellent introduction to the evolution of ODR and the relationship between ODR and the traditional dispute resolution processes Colin raised. And I'd like, can everyone hear me now? I'd like to address these issues by revisiting really, I think, 2 of the most basic questions we can think of. Revisiting the scope of ODR, really what ODR is, and the functions of ODR, what does it do, and underscore the ways in which these two questions, or the answers to these two questions, have evolved in the last few years, and possibly chartering some ideas for the future. So I'll start with the scope question. And the conventional understanding of ODR is that it represents ADR plus, right? ADR online, on the internet. And I think one of the major questions that has come up in all discussions is, does this understanding actually reflect what ODR is today and where it is headed? And I'll explore this from two perspectives. One is the online part, and the other is the ADR part. I'll start with the online. Is ODR necessarily linked to the online environment? And I think, on the one hand, it's no coincidence that both eBay and Wikipedia are represented here. These successful and popular websites are also leaders in the field of ODR. In both circumstances, the formal legal system and traditional ADR processes are typically unavailable or really impracticable. Now, eBay was a pioneer in realizing the significance of dispute resolution systems for enhancing user trust in the community they established, developed these unique, tailored, automated processes, and were smart enough to hire an in-house director, right, to design and oversee these operations. So while eBay is a commercial site, albeit one that sees itself as a community, Wikipedia is a not-for-profit project that draws on the users, as we've heard, to generate the world's largest online open encyclopedia. So Wikipedia introduced its dispute resolution system in 2003, and this seems to be following the significant growth in its user base, and maybe grounded in what Guy said in a broader ideological framework. Indeed, both eBay and Wikipedia are classic domains for ODR, right? They resolve disputes that arise online from online interaction between distant parties, typically strangers. Over the years, and these forums actually supply good opportunity to sort of see where we're at. I think if we look at the programs of these different forums over the years, I think our understanding of what ODR actually is has evolved, has broadened. Increasingly, we come to view ODR as being not only about resolving disputes that arose online through the internet, but also about managing, resolving, preventing conflict, whether it arose off or online, with the aid of technology, not necessarily online. And I think that is where Ethan's presentation takes us to this, new frontiers for ODR through the realm of digital medical records. Now, under this broader understanding of ODR, when we think of digital court projects or mediators employing negotiation support software to help parties, think about their interests, what their interests are, then all of these projects are really ODR projects, even though some of us may be saying these are traditional courts, just adding on a little bit of technology, and these are traditional mediators, just using some, technological tools that are now available. So after I've relaxed the online component, I'd like to examine the ADR factor in ODR. Are we merely transforming existing practices to another setting? And it seems to me that what we heard in the presentations demonstrate that the relationship between ADR and ODR is more complex than that, or should be more complex than that. I mean, on the one hand, our ODR systems obviously draw on the knowledge and experience gained in the ADR field, and they should do so, right? Because we are moving these systems or creating systems that were traditionally offline in the online setting, and some of these people, like Colin, actually came from the traditional ADR community. At the same time, however, emerging ODR systems and processes have also challenged some of the practices and assumptions that underlie traditional ADR processes. And I'd like to give you several examples. One example for the ways in which technology can upset some of the concepts and understandings developed in traditional ADR is in the realm of understanding disputes. What constitutes a dispute? How it evolves? At what stage can it be addressed? While traditional sociolegal scholarship has viewed the evolution of disputes as a multi-stage process, some of it actually taking place in the mind of the aggrieved, and I'm referring to Felsenor and Abel and Sarah's piece, ODR presents a somewhat different picture. We increasingly realize that technology can assist us in automatically detecting problems, right? Potential disputes, well before the aggrieved parties are even aware of them, and addressing these disputes. And we saw that, we can see how it, we saw that in Ethan's presentation, and Salil wrote about it, with the bots on Wikipedia actually fixing Wikipedia pages before the other side even starts complaining about it and getting into an editing war. Another area in which this compound relationship between ADR and ODR can be evidenced is the area of dispute system design. And here I'm relating to some of what Colin said. Both eBay and Wikipedia seem to follow the principles elaborated by Uri, Brett, and Fisher in their important book on this topic that was published, I believe, in the late 80s, Getting Disputes Resolved. So their work, which actually comes out of extensive research in the U.S. mining industry, gives us basic principles for designing dispute resolution systems. And sort of the main idea is to start off any system with interest-based processes, negotiation, mediation, and then escalate to rights-based processes, but offer low-cost rights-based processes and allow parties to loop back into those interest-based processes, and obviously also do some dispute prevention. And we see that, this is really the shape of both eBay and Wikipedia's dispute resolution system. So at first blush, it seems that they really follow these principles and perhaps even model their systems after this and other writing in the field. However, a closer inspection reveals that while ODR draws on ADR terminology, concepts, and structures, it also substantially alters their meaning. So take, for example, the arbitration process described by Salil. The process bears little resemblance to the rights-based process that is familiar to us from the physical setting. In Wikipedia, arbitration is used, as we heard, not to decide what the truth is, what an article should contain, what is relevant, what really happened, right? But rather to judge user conduct. In addition, instead of the common single decision-maker model, we have a group of arbitrators deciding a case in bank, trying to reach decisions by way of consensus. Arbitration decisions, we hear, are made public and are freely available. In eBay, the emergence of automated negotiation has raised serious challenges to traditional distinctions between negotiation and mediation, with technology playing the role of a fourth party, as coined by Katch and Rifkin, sometimes even merging what we knew as the third party, the mediator, with technology. So, while Colin was representing the pessimistic side, it seems to me that while traditional ADR carried a promise, right, for flexibility, tailored systems, it is often ODR that realizes this opportunity, or maybe has more of a potential to realize this opportunity by generating fresh structures that are tailored to the particular context in which they are applied. And this reality really presents a serious challenge for traditional ADR, with its ready-made molds and patterns that it currently offers. I want to say just one more thing about the functions of ODR. What does it actually do? So it is by now, I think, commonplace that dispute resolution systems not only resolve disputes. The norm-generating function of these systems is particularly evident in certain group settings, right, in closed groups. A well-known example from the traditional ADR setting is the research conducted by Lisa Bernstein on the diamond industry, where she found that this industry actually has its own well-functioning arbitration system that has its own norms that are separate from state norms and successfully enforces these norms. The presentations we heard on Wikipedia and other collaborative frameworks show the potential, at least, for such systems to be in place. But certainly in the case of Wikipedia, we can see how these systems can actually help shape interactions among users, right? In particular, strangers who come from diverse backgrounds and need to collaborate. So in these contexts, the dispute resolution system is not merely reflective of the values and the culture of the environment into which it is introduced, but it is also constitutive in that it teaches its users to relate and interact in a different way with one another. But then the question arises, how does it teach them to interact? And I think, correct me if I'm wrong, I think Salil's answer is that it teaches them through the outcome of the arbitration decision. That is what guides them in future contact. And I would like to suggest another possibility, maybe far-fetched, but one that I thought of. It may be that going through the dispute resolution process itself teaches them something about how they should behave, and not necessarily the ultimate outcome of the dispute. Having parties undergo collaborative ADR processes may actually prove to be a learning experience, one that teaches them how to interact with one another when they are collaborating, and thereby transforming the very fabric of social relations in these environments. So under this understanding, it may therefore make sense for the various arbitrators to collaborate and try to reach a consensus-based decision, not only for reasons of legitimacy, but also as a way of modeling the means of interaction for decision-making on the site. By the same token, it may come as no surprise that eBay opted for automated negotiation, where it didn't have to model necessarily such interaction and could settle for the outcome. But I'm happy to think about this further. So one of the issues, I'd like to leave us sort of with a few questions hanging there. And the question is, can we draw broader lessons from these experiences? And I find myself asking, under what conditions might ODR actually, first of all, might ODR systems actually emerge? And then we want to ask, why haven't they emerged? Where are the disputes? Where are they going now? And then, where there are ODR systems, under what conditions can these systems actually facilitate a kind of deep change in the way parties interact and in the fabric of social relations on these sites? Is it imperative that the environment these systems are introduced into actually operate under a collaborative ideology? Should we be surprised if indeed these things do take place? Should we be surprised that these forms of engagement actually emerge online? What many traditional ADR people see as a form of engagement that is cold, distant, poor with data. So I hope we can start talking about these and other questions, and I'm really happy we still have time to open this up. Thank you. So I think, would any of the panelists like to quickly say something, or should we just open it up to questions and let people who have been waiting patiently? So how about we open it up? Are there questions from the audience? Yes. Steve?
In reference to the eBay court system, do the jurors, when they're constituted as a body, at any point talk to each other, or are you just simply accumulating votes based on a single person sitting there reading the file?
Yeah, it's the latter. So the jurors don't communicate with each other. It goes to a jury of 21 in the eBay India case, but there's no reason why it couldn't be 50 or 100. But there's no opportunity for the jurors to communicate. We just aggregate the votes. But I think that the community court actually wasn't invoked explicitly during these conversations, but I think I'm glad that we had an opportunity to present at the beginning of the meeting, because I do feel like it is a response to many of the dynamics that we've named here. I thought that your presentation was very, very interesting in pointing out that there isn't a lot of dispute resolution systems for a lot of these social organizations, social media companies, that are YouTube or Flickr or whatever the users are generating. But actually, we have a lot of interest from a lot of these social media companies to integrate Community Court. So we're in conversations with Facebook about doing exactly that. We've been in conversations with Craigslist and some other, Yelp, which is another kind of review site. And it's an opportunity for the community to play this resolution role. And, I talked a little bit about sort of public policy and e-democracy. I think that this really is a way of democratizing dispute resolution in some of these environments. So the community court, I think, is an interesting response to some of the dynamics that were named in these presentations. I'm not saying it's the answer, but it's a response.
So I think that there were very interesting things related to the role of the community, and I guess the function of ODR that Orna was looking for. Salil asked us whether the Wikipedia experience can replicate itself. And I think that the answer is in the experience itself. I mean, the reason that people were so dedicated to the process in Wikipedia was that they were engaged in the process. And I think that that is a reason I may disagree with what Colin was saying before, that we don't have any online communities. Maybe our national communities are more integrated into our identity, but it is not that easy to exit an online community, especially if you are engaged. It's never easy to exit an online community if it's a mega community like Wikipedia or eBay or Facebook, because of the network effect. But even in a small community where you are invested in a process like dispute resolution in Wikipedia, that's what makes you link to that community. And I think on the one hand, and on the other hand, that is a basis for the fairness and justice, or what Orna was calling before, the legitimacy that people are looking for. So I think that the process is the essence, actually. And it not only produces the norms, but also socialize the community, and therefore creates the basis for the legitimacy. And I think that I disagree with the description of Guy about the absence of dispute resolution. Maybe it's not communal dispute resolution, but there's dispute resolution, right? The platform would decide what's on the platform and what does not go on the platform, and what it allows, what it doesn't allow. That's a way of resolving a dispute, right? I want to put something on YouTube, and I can't. And that is an unfair, maybe unjust, maybe illegitimate, but that's a way to resolve a dispute between me and the platform. So I think that there are lots of dispute resolution mechanisms, and I think that there is a lot of negotiations that we see nowadays between the residents of these online communities on eBay, on YouTube, on Facebook, and the owners of the platforms relating to these rules, the rules of behavior. And I think that this, creating these mechanisms would give these terms of use, the standard contracts, a lot more legitimacy, because it would keep the community in, and it would gain the legitimacy that they're looking for.
I'm Carrie Menkelmeadow. So I think one of my roles for the next 2 days as one of the founders of the original ADR movement is to raise questions about the tensions between ADR and ODR. So my comments are going to pick up a lot on what you were talking about. So you'll hear more from me tomorrow, but I'm a face-to-face ADR person. And my challenge or my question to the panel is, as Orna was outlining some of the goals of ODR versus ADR, I just want to remind everybody that two of the major goals of ADR was to provide, as you said, flexibility and tailoring of both processes and remedies. And what we see up here in a lot of instances is through volume processing of disputes, less tailoring, less flexibility, rote remedies, same kinds of remedies, or the bidding process, very simplistic allocation through monetary or quantitative terms. So that's any one of you want to pick up on that. To the extent that ADR promises flexibility and tailoring, to what extent does ODR reduce that? I think it does, but I'm happy to engage with you. And secondly, one of the major promises of traditional ADR was to promise confidentiality to the parties so that they could honestly share their innermost, deepest, most interests in a confidential private setting where nobody else would have access to it. And the medical records thing is an issue I've been following in the States, too, very problematic. But even picking up on the computerized information management thing, which as an arbitrator, as a user, as an arbitrator, I value, obviously. It decreases costs in arbitration. I am an international arbitrator. The other side of it is that cases may now be available. Now, the part of me that believes in public justice and everyone having the right to see outcomes values that. The lawyer in me, who might represent parties who choose arbitration because they want private dispute resolution systems, gets nervous when she sees that outcomes and cases may now be available in databases and reports, as we heard, and sources in dispute systems that promised the parties confidentiality in use. So I don't know whether anybody wants to comment on, more issues. I just here highlight flexibility, tailoring, and confidentiality as at least two things that old ADR promised that I worry a little bit about getting lost in ODR.
If I can talk just really briefly about those, I think that I don't know as much about actual real-world ADR, but from what I understand, I think that it couldn't be more different in some respects on those 2 points than the Wikipedia system. I mean, even though many of the same people might work in international ADR, right? You have panels drawn from often very large rosters, so you don't always have the same 12 people, right, dealing with something. And I think that with the Wikipedia example will tend to reinforce this routine or this kind of pigeonholing of cases. And then the privacy, I mean, except for the fact that these people have these anonymous handles, I mean, otherwise it's completely displayed for years. So I think you're right to think that this is like through the looking glass on these 2 points.
Well, I guess I disagree with both of you. I don't think this is working, though. Is it working? And it's a very interesting set of questions, though. I mean, how do we even conceptualize flexibility or tailoring to an individual? Alternative dispute resolution typically categorizes the forms of dispute resolution as mediation, arbitration, and negotiation. I think ODR doesn't have to accept any of those. Those are different ways of using information, basically. ODR has the potential. So I think it's certainly arguable. Your case is arguable if you're talking about ODR today. But ODR in the future, when there will be a whole array of capabilities for using information that are not available today and that are options that are not available when meeting face-to-face, we'll have a new kind of flexibility or a different kind of flexibility and certainly a different kind of tailoring to an individual. Really what I want as an individual is redress. If I have a problem with my credit bureau, I want a way to deal with that. Now, I think there certainly is an intriguing question about whether these are disputes or issues or problems or something. In the electronic medical records area, the tradition is if it's a minor problem, it's settled in between the patient has a minor problem, disagreement, settles it informally with the doctor. Patient has a major problem, sues for malpractice. What about all the stuff in between? Well, I think the electronic medical records are going to reveal all the stuff in between. And that's where we need fair, flexible, responsive responses to these problems. Are they disputes? Maybe that's a bad, just an inappropriate. It's a word that has outlived its usefulness. As far as confidentiality goes, the whole society is reorienting its way of looking at what information is revealed and what's not revealed. The question that used to be asked about confidentiality is, if I have an online mediation in which information is flowing over the network, how can I guarantee confidentiality? We haven't had any problems with that. Colin has 40 million disputes a year. I don't know if anybody ever raises that issue anymore about confidentiality. The fact that arbitration decisions may be online, yeah, I think there are pressures to put all kinds of data online. That's again, one of the waves of technology we're experiencing. Because these things can be put online. The ICANN, the domain name disputes, are online, but were not put on. It took us probably 6 or 7 years before they were put online in a usable way. Now those are, I don't want to get into that now because you'll hear more about those disputes later. Arbitrators say those aren't even arbitrations. There's something else because they're not enforced in court, but essentially they are arbitrations. They're online. There's no precedential value in the decision, but consistency, information is online, striving for consistency, there's almost an inevitable outcome there.
Well, as the person who I think created this contrast between ODR and ADR in my presentation, let me begin by knocking it down. I believe that, I have a good friend in the ADR field who has said to me repeatedly, all you have to do is squint a little bit, and it's very hard to tell the difference between ODR and ADR. And a lot of people who are in the ADR field are using technology in their practices, or using email and faxes and track changes and all those sorts of things. They don't even think twice about it. So there is a merger that's happening there. And at least in looking back at the origins of the ODR field, it was very explicit that this was a clear outgrowth of ADR. And we were just trying to use technology to make ADR work better. That was that was our mission at the beginning. And then over time, we've learned that there are some things you can do online, you can't do offline. And you're not going to find anybody, I think, in the ODR field who says, oh, we should do online in lieu of face-to-face. I think now there's a clear understanding that there's a spectrum between both, and we embrace these hybrids and all those sorts of things. But I guess the longer-term argument that I would make is I sort of agree with both of you. I think both of the points that Carrie raises, I think, at its best, both ADR and ODR can deliver confidentiality and flexibility. Now, there are many implementations out there that do neither of those things. I think both in the face-to-face world and in the online world. I do think that the reliance on code and the fourth party that Ethan and Jana came up with does create systems that, in a sense, are a little less flexible than when you're sitting in a room with a dynamic mediator that can work with you and change the process, on the fly. But at the same time, there are huge advantages that can be gained from using technology in that way as well. So I guess when I raise the issues, the challenges the ADR field is facing, I think they exist for the ODR field as well. And I guess what I wanted to do, I know that I think Orna said in her presentation that she sort of saw me as representing the pessimistic perspective on some of this. But I do think I fundamentally am an optimist in that we can achieve the goals of both the ADR field and the ODR field by using these tools. And I guess what I wanted to do is sort of urge us to tackle them more proactively so that we can deliver on what we wanted to achieve in both of these disciplines as opposed to kind of where we are currently in practice.
I think your points are very well taken, and I think they point to certain limits. I think one of the questions we need to ask ourselves, are these limits constant or are they shifting? And we sort of need to reflect on that once in a while. Certainly there are disputes where you would not want to have them online. You wouldn't want to have the resolution posted online. But I think we have also, and I connect myself to both worlds. And I think in my hat as a traditional mediator, we have become accustomed to this, blanket confidentiality, always having the same level, quite a broad level of confidentiality, and have not revisited that notion and sort of how we look at confidentiality offline as well. So I think that's it for me, and I'm happy to open it for more. I see Nancy.
I want to begin just by saying I think this has just been fantastic, and so thank you all. I was really struck, Colin, when you said that within eBay there's a debate now between whether or not disputes will resolve using fairness as the norm or the norm of the customer always being right. And just in this last round of discussion, that harkening back to ADR, I'd like to suggest that because ODR is about mass processing of cases, in some ways we should be harkening back to litigation. So, what ADR grew out of and as a reaction against. And for example, as you were talking about that, I thought, well, I wonder what standard of review those 21 jurors are using in deciding who wins, whether or not the feedback will be withdrawn. And if it's a standard of review that provides some kind of a presumption for the customer, pragmatically acknowledging that that's who he is concerned about, then maybe there is some way to reconcile, still have something that is fair enough, and at the same time recognize this reality. So I just would be curious on your reactions to that small point, but then also to the larger point of not just looking to ADR, but looking further back to see whether there are useful lessons that don't necessarily need to be copied, but at least considered as ODR is trying to come up with ways to resolve these things.
Well, I can just talk loud. I have to say, well, first thing I'd say is the community court has only resolved, 1,200 disputes, and the principles of online dispute resolution at eBay have resolved hundreds of millions. So I don't want to put the cart ahead of the horse in terms of saying, oh, the community court is the future, let's all jump on board. There's certainly a lot of challenges that we need to wrestle with, and one of those is what are the objectives for decision, what should be the qualifications of juries, how should we design these systems for different types of disputes that we wrestle with. So the reason why I'm so excited about it is because it is new and we've got to figure those things out, whereas a lot of the assisted negotiation things we've been talking about are much more well-trod areas in the eBay context. But I guess maybe that is what I'm saying is in the ODR field we should think beyond the constraints of our traditional definitions, and I think the community court is an opportunity maybe for us to think about the court example. And why is it that this judicial model has proven so pervasive in the minds of people around the world? I think, at least in my early days in the dispute resolution field, ADR was defined as really counter to that judicial model. And I guess maybe the community court is my experimentation, in a sense, with embracing some of those models and taking on some of those challenges. I'm not saying that anything's a panacea. I mean, I think one of the tenets of dispute resolution has always been let's have a broad toolbox and let's design systems dynamically based on the types of issues that are coming in. So I don't want to be doctrinaire about any of this. I guess what I want to say is let 1,000 flowers bloom and let's see what works and what doesn't. So if anybody's interested in the community court example, please come to the afternoon session because literally we are in the process of figuring out how this is going to work. And, I think just like the ADR to ODR example, where we learned that some things worked well and some things didn't work well, I think the community court, we're going to have the same learning curve that we need to clamber up. And I don't know if we're ever going to get to hundreds of millions of disputes through it, but it's definitely an interesting thought puzzle.
Jeff?
Hi, Jeff Oresti. The one thing I would go back to is this issue of calling this field dispute resolution. As a lawyer, this really should be more about building relationships and avoiding disputes. And the use of online in a global setting, you just got rid of the lawyers and started focusing on a global environment application rather than just saying, let's take this traditional legal system and port it over in an online environment. It just doesn't work. It doesn't work in eBay, doesn't work in Facebook, doesn't work in Wikipedia. If the courts ever thought they were going to get into those cases, or even ADR for that matter, it wouldn't work.
I think again that this is an extremely interesting debate, and I would just like to add that because we are speaking about online dispute resolution, it is mostly or usually also cross-border, and it will be more and more cross-border, and also it will deal with multiple languages. And this also puts the discussion about flexibility and tailoring in a new perspective, and we need to think of flexibility and tailoring in the multilingual environment.
The issue of maybe beyond multilingualism of culture is kind of hinted, I think, by Salil when he mentioned that they only dealt with the English Wikipedia dispute resolution system, and I thought it would be fascinating to look at the other, Wikipedia languages and cultures and see if we can find differences. And I think from that, I'd like to take it to another point. I was asking myself as we were talking here, to what extent can we actually examine one process that takes, when Salil also was talking about the arbitration, and so much is happening outside the arbitration, and in other contexts as well. On the one hand, it's debilitating because it's very hard to examine the entire spectrum of what's going on a site like Wikipedia, but on the other, it does probably skew some of the conclusions we get at when we look at part of that, and that's certainly true with respect to the more global scene. We have a mic? Oh, okay. Any other questions? Yes.
I wanted to ask about enforcement. I mean, when we're talking about Wikipedia, when we're talking about eBay, what happens if someone, just goes away with the money? How do you compel them?
With Wikipedia, part of what was going on, and this is where I think Orna's point is well taken in terms of there's a lot of moving parts. Part of what's going on is that the arbitrators are actually sending a signal to the administrators about what actions they can and can't take, either in that specific case or generally, right? And so, they actually hunt those people and sort of figure out who's created, and that's why you get these sock puppet bans, the idea that you're pretending to be someone else. So you can, but they're actually fairly sophisticated at tracking that or figuring that out, both through human sort of means as well as technologically.
Yeah, the fluidity of identity makes enforcement a big challenge, but that's something that big companies like eBay and PayPal have invested in an inordinate amount of resources to tackle. And we have a lot of very sneaky ways. I can't tell you what we do because I'd have to kill you all, but there are a lot of very technologically advanced ways that we can hunt down that problem. Now, but I think you put your finger on a key issue, and I mentioned this before. I think I did it very briefly in the first 15-minute presentation. In my experience, enforcement is crucial to online dispute resolution. And if you look at all the successful ODR schemes, they have had built-in enforcement. If you look at ICANN, ICANN owns a database. When they decide who owns a domain name, they flip a switch, they have just enforced it. At eBay and PayPal, we move the money. That is why eBay paid billions of dollars for PayPal, because you cannot have a redress process unless you have the ability to get the money and then give it back to the other side. Without that ability, you're all just whistling Dixie. And I think, it's a lot of interesting questions about why does Wikipedia throw people off the site? Because they can. That's one of the few things they can do. If they could charge you $100, they would. But they don't have that ability. So you're going to use the tools at your disposal in order to execute your outcomes. And I think that's a very interesting point when you look at some of these other social media sites. What power does Facebook have over its users? Well, I don't know. Some pretty scary powers. That's make people pretty paranoid about what Facebook would do with all of that intimate information. So I think that the enforcement question is crucial. And this makes me think of one other point that came up both from Orna's commentary and also from a couple people in the audience. I think that, and again, I share this, so please don't take this criticism as being me pointing a finger, because I'll point it right back at me. What? If I point, this is a dispute resolution thing. If I'm pointing at you, 3 fingers are pointing back at me. So, one of the things that we want is that we want dispute resolution systems to be, in some senses, educative or ennobling or create more of a community. And I do think that there is an element of these systems that, with Wikipedia, when there is a resolution process, it does underscore the trust in the community, and that makes people feel more loyalty towards it. But I must point out that these processes are not the value proposition for these sites. Nobody comes to Wikipedia because they want to participate in the dispute resolution process. No one at eBay is spending their endless hours clicking through listings because they hope they get a dispute so they can use my process. No, they want to collect Hummel figurines. There is a positive aspect, and the dispute resolution process normally is interpreted as something that is an unfortunate necessity. So I think that we shouldn't put on rose-colored glasses and think that these things are, somehow ennobling for these communities. Most of the time, they're necessary, but I've said before, it's kind of like the dentist's office. Nobody gets excited about the dentist's office on a daily basis, but if you have a toothache, all you can think about is the dentist's office. So that's what dispute resolution is in these communities. It's necessary, but it's not part of the value proposition.
About eBay, what percentage of dispute resolutions doesn't end up getting really resolved? And then in general, what is eBay's responsibility or liability, if at
all? There's a couple different good questions in there. eBay has different dispute resolution mechanisms that act kind of like a filter, like I talked about. So pretty much every dispute gets resolved. The question is, at what point does it get resolved? eBay wants these disputes to be resolved as early as possible, preferably before they're even a dispute. But if you can engage in direct negotiation between the parties, you can resolve a certain percentage of disputes. If you get through all of that direct negotiation and you get the tracking information and the partial refund bidding and everything that we do on the process, and it's escalated to a claim where the users ask eBay or PayPal to decide it, which usually only represents about 10% of incoming volume, then we render a decision. And that decision is binding under our user agreement. Now, of course, you can always sue. You can always go to the courts. There's nothing in the user agreement that blocks you from pursuing that channel. But the interesting thing about these communities, even with the hundreds of millions of disputes that we've done, it is a tiny, tiny percentage of cases that ever get appealed outside of the redress mechanisms that we provide. So I think these dispute resolution mechanisms have proven pretty effective. But again, that might also have to do with the fact the average transaction value is about $100. So there's not a lot of incentive for people to go sue unless they've really got an axe they want to grind. So we've proven the effectiveness of these mechanisms. But the question, and I think this gets back to the core issue that I had, is that buyers go through this process and say, you know what, I'd rather just go to a site where I win every time. And hey, I'm not happy. Great, here's your money back. Keep the item. That's not fair. That's not a just outcome. But a lot of buyers would rather be given an unjust outcome as long as it's in their benefit. And that's another truth that we need to wrestle with in terms of building these systems.
Well, I think that this is, it's interesting. They have their own sort of reputation with their username. It's not the same kind of reputation that it cannot be translated into, as you say, $100. There is, to some extent, there is that, and so there's a potential that they're trying to vindicate some sort of harm to their dignity. And that is I think that is a source of a lot of the complaints that they get, is someone feels that they've been wronged in this way. And so, in a way, maybe it is an atypical dispute resolution system in the sense that it's really dealing with non-pecuniary conflict, right? and trying to deal with it and channel it or deal with the person who cannot be rehabilitated. So if that helps.
Okay. I want to one quick. Okay, Marta.
You mentioned in your presentation a key concept of the next wave of ODR, which was crowdsourced solutions. Can you just expand a little bit more on that? Because I'm using mostly the same word in my presentation, and just to check about the meaning of this.
What did I mean by that?
Yeah.
So crowdsourcing, I think, in a Silicon Valley context, I'm not sure if it has a dictionary definition that's different than this, but it's taking a complicated problem and splitting it into 1,000 pieces or even 1,000,000 pieces maybe, and then having lots of people do a relatively simple thing, and then reaggregating all those contributions back into a relatively sophisticated solution. So crowdsourcing, there's been a couple examples of websites that do this. And I think the Community Court is another example of using this principle of crowdsourcing to tackle dispute resolution challenges. But I think one of the reasons why I'm drawn to crowdsourcing is because I do think it's connected to these notions of e-democracy and public participation. So, when we were talking about all these websites that don't have dispute resolution mechanisms, they don't want to decide these disputes. None of these big technology websites, the only reason they do so is because they're forced to do so due to liability concerns and because of community credibility. But if they had a mechanism where turnkey almost, they could say, look, have the community resolve these issues in a way that does not reflect on us as the community administrator, I think they do it in 2 seconds. And I think that long term, it creates more of an institution, an institutional expectation that is in line with where we want to head. Now, it also undermines this notion of the dispute resolver as a professional, as someone with a unique set of skills, and it's almost using mass people to play a role that we used to say, well, let's hire professionals who receive this training and have this expertise to do it. So, I think that that's something we need to resolve, but hopefully that's in line with the way that you're planning on using it.
Okay, I'm going to use my prerogative and say one last word and then a few messages and then we're off to lunch. One last thought I'm sort of left with, and I think it picks up on the flexibility point, is maybe we're asking a question also about what makes dispute resolution systems evolve, whether they're online or offline, and what makes them sort of stagnate or remain fixed. And I think it's interesting to know, I think, Salil, correct me if I'm wrong, but in your paper, you write it's been very difficult to actually change the Wikipedia system. It's kind of stuck, right, where it is. Whereas eBay has been, really innovative and changing. And these are some of the questions I'm asking myself. And, when we look at ADR in the institutionalized setting, the law has had this co-opting effect where it kind of reduced ADR to one form. So just a thought to be left with. And some messages. We're off to lunch right now. During lunch, we'll have a technology display inside the room. Lunch is set out outside, I believe, or if I'm correct, we'll know that in a second. We'll walk together. The rest of the conference today is in another area. We'll walk there together a little bit after 2. And we actually have 2 sets of concurrent panels. So we're only going to reconvene for dinner, which will leave here at around 6 or 6:30, right after we finish, to a beautiful Druze village, Daliat el Carmel. The good news is we're going to be there, and it's going to be an exciting local experience. The one caveat I need to mention is we're going to respect the family we're being hosted by, and we're not going to have alcohol served there. So if anyone is very eager to have alcohol, you can have it before or after, but not there. And hopefully we'll get a chance to see the market there. Enjoy lunch. Bye.
לא, הם מקבלים דמי אבטלה. אני אמרתי ששיעור, אני חושבת שאני אמרתי את זה מאוד ברור, שיעור הבלתי מועסקים במשק הוא גבוה מהשיעור של אלה שמקבלים דמי אבטלה. אבל חלק מהם, לצערי, לפעמים התייאשו. זה חבל שהם לא בעולם העבודה, כי הם התייאשו שהם למצוא מקום עבודה ההולם את כישוריהם, ולפעמים הם מעדיפים לחיות ברמת הכנסה ממקורות אחרים נמוכים, לפעמים בעוני, משום שהם התיישרו למצוא תעסוקה שהולם את הכישורים שלהם ואת הרצונות שלהם בשוק העבודה, ואני בהחלט חושבת שלהיכנס לשוק העבודה צריך להתנהל דיאלוג בין דורש העבודה לבין מי שעוסק בנושא הזה, ולא לכפות, כי בסוף לטווח ארוך הכפייה הזאת לא מניבה, הייתי אומרת, תוצאות משמעותיות בנושאים האלה. אם אני לוקחת את שוק העבודה בכלל לפי סוגי האוכלוסיות, ואני מבחינה, וזה מעניין, כי שוב, אם הנושא של ההון האנושי, ואני חושבת שצריך להיות יקר, כי אם אנשים השקיעו בהשכלה שלהם, אם אני אקח את אוכלוסיית האקדמיים ורכשו כישורים, הרי חבל שהכישורים האלה ירדו לטמיון על ידי זה שאנשים האלה לא השתלבו במקומות שבהם הם יכולים לתרום כתוצאה מהכישורים שרכשו על ידי רכישת ההשכלה. אז אם אנחנו מסתכלים על בעצם על כל סך הכל בנתוני מגמה של סך הכל האוכלוסייה שהיום נחשבת דורשת עבודה במבחן התעסוקה בשירות התעסוקה, אני מדגישה כדי שלא יהיה פה ויכוח לגבי הלמ"ס. הלמ"ס מדבר היום בנתוני מגמה על 243,000, הפער הוא 23,000, הרי שהבטחת הכנסה זה השיעור שלה, מקבלי, לא הבטחת הכנסה, זאת אומרת אבטלה בלי אקדמיים זה 70,000, בבקשה, חשבתי שיש לי פה מיקרופון. מכל מקום, היות שהבטחה אקדמיים, ללא אקדמיים, זאת האוכלוסייה הזאת, ואקדמיים, יחסית שיעור המובטלים בקרב האקדמיים הוא יותר נמוך. אם אנחנו נסתכל על הפרופיל השכיח, ואתם יודעים שעל הפרופיל השכיח של תובע הבטחת הכנסה, תראו כמה שזה פשוט תמונה חיה בעניין הזה. תראו, אנשים שנמצאים באוכלוסיית הבטחת הכנסה, מבחינת הגיל, הייצוג בגיל 73.5% הם הגיל השכיח שלהם, לא הממוצע השכיח, הוא בין 35 ל-64. למעלה מ-60% זה נשים, והשכלה היא עד תיכון חלקי, הייצוג שלהם הוא 56.8%. זאת אומרת שאם אתם מסתכלים על הפרופיל, נשים, בעלי השכלה, בעלות אני יכולה להגיד, השכלה נמוכה, וגיל, לצערי זה היום אחד האבסורדים היום של שוק העבודה, שאנחנו מנסים להילחם בו. תראו, למרות שגיל הפרישה עלה ל-67 לגברים ובהדרגה יעלה לנשים, הרי שבשוק העבודה כל הזמן מורידים את הגיל, והקשר הזה, הרי יש פה כלים שלובים. אם אתה הערכת את גיל העבודה ואנשים יצאו מגיל העבודה בגיל 50, אדם נחשב זקן לגיל לעבודה, ויש מעסיקים שלמרות שזה בניגוד לחוק כמובן של שוויון הזדמנויות, הרי שאנשים לפעמים מדברים על 35 שזה מבוגר, על 40 הוא כבר מבוגר, אבל זאת התמונה. מבחינת שיעורי הפרופיל השכיח של זכאי אבטלה, הרי שאנחנו מדברים על מצב קצת יותר טוב, שם הייצוג של אנשים יותר נמוך, אתם רואים שזה 55.1%, אנחנו רואים שהגיל שם יותר נמוך, והשכלה היא כבר קצת יותר גבוהה. גם כשאני מדברת על השכלה תיכונית, זה בדרך כלל כמובן בלי תעודת בגרות, ולפעמים זה ספרות וכל מיני צירופים, מזכירות ודברים כאלה, שכמובן כשאנחנו מדברים על השכלה עיונית, אנחנו לא מדברים. הדבר המדאיג ביותר זה עומק האבטלה בשוק העבודה. כשאנחנו מדברים על עומק העבודה ותסתכלו מה שקרה, יש לנו גרעין קשה של 36% מה-220 שאני הראיתי אותם קודם, שזה 78, כמעט 79,000 דורשי עבודה, שנמצאים הרבה מאוד זמן במצב שהם בלתי מועסקים. ש270 יום בשנה הם לא עבדו. ויש אנשים שאינם עובדים 3, 4, 5, 6 ו9 שנים שלא עבדו יום אחד. אנחנו פוגשים, ואני אומרת שוב לצערנו, דור שני ודור שלישי של אנשים שלא עובדים. ואני אומרת שוב, אני עצמי מאמינה בלראות את הדברים בעין, לא רק משולחן של המנהל. אני פוגשת הרבה פעמים בלשכות שלנו בשירות התעסוקה, אני יושבת עם הפקידים לראות מה הדיאלוג המתנהל, מי האנשים שמגיעים. אני רואה אישה בשנות ה-40. היא ובעלה לא עובדים שנים. אני שואלת אותה, תגידי, הילדים שלכם מעולם לא ראו אתכם יוצאים לעולם העבודה. מסתכלת עליי, כן, אז מה? והיא בריאה, היא בריאה, היא יכולה לעבוד, והיא לא נמצאת בעולם העבודה. והיא עבדה בעבר בתחום התעשייה. אני שואלת אותה, ובעלך הוא עובד? היא אומרת לי, לא, הוא מקבל קצבה. זאת אומרת, שני בני הזוג נמצאים בבית, שניהם בעלי מסוגלות לעבודה, הילדים שלהם מעולם לא ראו אותם יוצאים לעולם העבודה. אני לא בטוחה שזה מצב אידיאלי, גם כשאנחנו מדברים על העניין שיש הרואים ניסיון להוציא אדם לעולם העבודה כאיזשהו ניסיון להרע או לפגוע במישהו, ואני מסיירת את עצמי. כשזה נעשה בצורה נכונה, תוך ניהול דיאלוג, תוך מתן הכלים והקניית כישורים, אני לא חושבת שזה עונש. כשאני